Thank you, Mr. Speaker, members. We all know what people generally do when they don't have good arguments to respond to an assertion. Turn to an homonym, turn to red herrings, compare things to difficult struggles that involve contentious issues, civil rights, the Civil War. That is not what we're talking about here. As Representative Gottwald clearly pointed out very well, and Representative Gruenhagen referenced this too, this is different. For decades, our country has been walking down a road to a cliff. The cliff is getting closer and closer. And what is the cliff? The cliff is the end of any limitations on the powers of the federal government to regulate and pass laws that affect Minnesotans, or people from Rhode Island, or people from Massachusetts. The cliff is the end of state sovereignty. The cliff is turning the 9th and 10th Amendments into meaningless recitations that are ignored wholly. And the cliff is eviscerating the enumerated power structure of our Constitution. James Madison, I think, was a pretty smart guy. He, in 1798, saw a law come down from the federal government, which was pretty young then. A couple of laws, the Alien and Sedition Acts. None of us were born yet, but we know our history and we know what they were. Part of those laws basically banned speech against the government. What did Virginia do? What did James Madison and the Virginia House of Burgesses do? He passed the 1798, he led an effort to pass the 1798 Virginia resolutions that stated that the Alien and Sedition Acts were null and void because they were beyond the power of the federal government to enact. Members, where would we draw the line? What kind of laws are we willing to accept just because the federal government passes them? If this Affordable Care Act is acceptable, and we think that the federal government has the power to regulate inactivity and tell us what we can and cannot buy and tell us how to use our money, what's next? Where do we draw the line? So the argument that this is a crazy argument, well, the statement that this is a crazy argument is just simply not true. It's without merit. What's crazy is to ignore the road we've been going down for all of these years and to ignore the erosion of the protections built into our Constitution by the framers. Members, I ask you to think a little bit about the 18th Amendment, passed in 1929. I believe. But prohibition, the 18th Amendment, banning the sale of alcohol. That was 1919, wasn't it? Whenever it was. Thank you. 1919. The 18th Amendment. Why did Congress feel necessary to pass a constitutional amendment to ban the sale of alcohol in the United States? If the question were to be debated now, do you think Congress would pass a constitutional amendment to ban the sale of alcohol, or would we just pass a law? Congress would just pass a law. We do it all the time. Congress does it all the time. Not speaking to the merits of various laws with regard to outlawing drugs, but I'm just speaking to a point. And the point is this, that we have gone down a path from 1919, when it took a constitutional amendment to ban the sale of alcohol, to now, where Congress presumably would do it by just simply passing a law. That demonstrates the erosion of the enumerated powers protection in the 9th Amendment and the 10th Amendment in our Constitution. That is a good demonstration of where we're going, and it shows that the cliff is coming. Now, Representative Huntley raised a few points. He referenced the state of Massachusetts and their law affecting health care, which is similar to the Affordable Care Act, insofar as the Massachusetts law would impose as a penalty on persons who do not either purchase insurance or find coverage under a government insurance program. But members, Massachusetts is a state, like Minnesota. Massachusetts has plenary power to govern and to pass laws affecting public health, welfare, and safety, just like we do here in Minnesota. That's what states do. That's the difference between the states and state legislatures and the federal government. Massachusetts is like Minnesota. Massachusetts is a laboratory of democracy. And we should look at the laboratories of democracy and see what they are doing to determine what may or may not be a good idea on a federal level, provided that, of course, the federal government has the power to do that thing. And if we look at Massachusetts and what it did, even assuming that it would be constitutional for Congress to adopt what Massachusetts did, well, Massachusetts is a mess. Costs are skyrocketing, and that goes to the points that Representative Gruenhagen, Representative Gottwalt, and others have spoken to very well already. And the comparison to auto insurance doesn't work either, because, of course, the federal government doesn't regulate auto insurance, and even if it did, you don't have to drive cars. But you do, if you want to live, have to breathe. You can't opt out of purchasing health insurance under the Obamacare regime like you can opt out of driving a car to avoid the requirement of purchasing auto insurance. So it just doesn't compare. So members, this is a very serious debate, and it's about time that we start thinking very hard and very long about what our Constitution means, what our state Constitution means, what our federal Constitution means, what it means to have a system of dual sovereignty, and what are we, who took an oath, as Representative Gottwald pointed out, to uphold the federal Constitution and the state Constitution, going to do to make sure that our liberties are preserved and that the federal government does not continue to grow at the expense of the states, and that we can continue to pass legislation here in Minnesota for Minnesotans that protects Minnesotans, and that the Congress in Washington, D.C. can pass laws for the nation in the manner that our framers intended. Please vote green.